You just can't seem to follow the rules.
She kept chasing me. That's it. And then she wanted to talk about calling the police and all that. She control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges.
I understand.
You just need to just stop blaming them.
Miles Carter. Thank you.
Mr. Burgess.
Welcome back, guys. Buckle up for this one, because it goes off the rails fast. Judge Simpson's got a defendant who apparently thought his ankle monitor was more of a fashion accessory than a court order. Not only did he tamper with it, but he also decided to meet up with every woman he's legally banned from contacting, like it was a social event, not a violation. You can literally see the judge's patience evaporate in real time. Bonds aren't given so you can test the limits. They're given so you can prove you can follow rules. But this guy, he's out here treating probation like a challenge mode. Is it arrogance, stupidity, or a mix of both? What do you guys think? Does he deserve another chance? Or is this game over? Let's dive in and watch.
The PE is scheduled for tomorrow morning. I believe.
On the one case, I have a new case, however.
I was unaware there were new charges, Judge. But I don't know if this court's prepared to arraign my client.
I am.
Okay.
And I don't know. We're going to stand in for the purposes of the arraignment.
I'll be filing an appearance, Your Honor. I was unaware, but the charge, I would have filed one already. So.
It's a charge of interfering with electronic communication device, the 2-year felony, and then also domestic violence, second offense, the 1-year misdemeanor.
Yes, Your Honor. As it relates to both those charges, waive any further reading of the warrant. Stand mute to both those charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. I'll set a probable cause conference in that case for, I need a DV bond form, please. For November 14th, 2024 at 9 a.m. or as your invite indicates. As to bond in that case, you want to say?
Yes, Your Honor. Obviously, Mr. Carter's here on his own voluntarily this morning and this afternoon. And obviously the court knows his history of appearance in front of this court. And Your Honor, he just got a new job. He was, unfortunately, he lost his other job due to this incident, but he just got a new job that he'll probably lose if he's in custody. Judge, it does appear that the complaining witness in both these cases is the same person who has actually reached out to me before, Your Honor's indicated her, I believe, unlikeliness of appearance in the case. I don't think she wants to proceed with the case, but that's my understanding anyway. People might have a different position, Judge, but she's reached out to me independently and indicated that she does not want to proceed with those charges. But be that as may, Your Honor, I don't believe my client's a flight risk, and he's still on a tether, Your Honor. He did post a significant bond in the last case. Understand these are new serious charges, Judge, but I'm asking the court to consider a nominal 10% bond, if not a personal bond in this case.
Anything from the people?
Your Honor, I have some advantage because I do have the police report for the newest case. Mr. Burgess does not, but I will indicate to the court a few.
This guy didn't just fumble. He sprinted straight into legal traffic, holding a sign that said, "Arrest me." Judges don't hand out second chances so you can treat bond like a weekend pass. The moment he messed with that tether and met up with the victim, he basically lit the fuse on his own case. Now he's standing there acting shocked that it all blew up in his face. It's not bad luck, it's cause and effect in its purest form.
First of all, this court arraigned defendant on not his newest felony that he was just arraigned on, but the one that's set for preliminary examination tomorrow on October 7th. At that time, the defendant was ordered not to have contact with the victim, Jennifer Matlock. The new date of offense for the newest case that we're here for today that the defendant is alleged to have committed is October the 20th. So weeks later, and I will tell the court after review of the police report, the person representing themselves to be the defendant did have contact with the police officer and admitted to having contact with the victim. Denied the assaultive behavior, but did admit to having contact with her. Now, because the defendant, because the police officer was speaking with the defendant face to face. I cannot say with absolute certainty that it was the defendant. However, the police officer did a very good job in their report of detailing how he came into contact with that person, that this person kept called him back or presented themselves to be the defendant, and said that he would turn himself in for the bond violation. I don't have a record that actually happened. So Your Honor, in any case, this is somebody that was on the scope of probation, on bond for a felony, and now has picked up another new felony. So I am asking the court to follow probation's recommendation, revoke the probation, and sentence the defendant to serve balance at this time. And in bond, in this case, we're asking for $100,000 for the new felony.
Court will order as a condition of the bond that there's to be no possession of any alcohol, illegal drugs, or any recreational marijuana. Better, I'm not entirely sure what is going on with you in that regard. I ordered you on the 7th not to have contact with this person. And then lo and behold, we end up with this case occurring less than 2 weeks later. And tried to give you every benefit, and I understand there are only allegations, but try to give you the darn benefit of the doubt regarding everything, because of at least the way that you conducted yourself in regards, particularly regarding being a flight risk. But you just can't seem to follow the rules.
Your Honor, I'm sorry. I don't mean to interrupt.
Go ahead.
I'm sorry, Judge. Judge, the incident on the 20th, based on conversations I've had with my client as well as the complainant in this case, the complainant approached my client, asked for a phone back he had purchased, but it was in her name, which he returned to her. That was the basis of the contact. That's our understanding of it, Judge. So I wouldn't. But
Right. But the thing is,
I know.
he needs to be turning around and running in another direction. He shouldn't even be having a conversation, shouldn't be doing anything
I agree.
whatsoever. I don't think it's at all unclear as to anything that this court has said to you regarding what you need to do. And you need to just follow the rules. I gave you a break the last time that you came in. Even after that, let you go.
Simpson, can I say something?
You can say whatever you want.
I understand. Just, she put up on me. I was in the room playing my game.
This is the part where reality hits like a truck. He's got a restraining order. He violated it. And now he's about to deliver the world's worst defense speech like it's going to save him. Judges don't care about good intentions. You show up somewhere you're legally banned from, that's game over. No debate. And the fact that he's still standing there trying to argue, that's not confidence. That's straight up delusion in a suit.
Chasing me. That's it. And then she wanted to talk about calling the police and all that. She's chasing me. She's chasing me. She's chasing me. I hopped in my car and that's when I pulled off.
Well, maybe that's all going to come out, Mr.
I understand.
Carter. Maybe that's all going to come out. I let you out the last time. Should have, of all rights, locked you up on that date. Didn't do it. Gave you the benefit of the doubt because of the time that you came back after you were inadvertently released by the jail. And then what happens? You get that other case set for exam. Then what ends up happening? I get here and you got another case.
It's a control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges.
I understand.
And you're the one under the jurisdiction of the court. So however you got to figure it out, you need to figure it out.
Yes, sir. Yes, sir.
Defendant's bond on that case would be set in the amount of $100,000 cash surety. On his other matter, anything you want to say before I pose sentence on that case?
I want to say, I tried my hardest. I tried my hardest to do right. I tried my hardest to stay away from women that want to see me in jail rather than see me elevate myself. So, I mean, I understand. You understand it. When I get out this situation this time, I'm gonna be by myself. No,
You know what you ought to do, Mr. Carter, and I don't mean to interrupt you. You have the right to allocute, but I'm just going to tell you something. You ought to quit blaming them. You just need to just stop blaming them and thinking that they're the ones that stop you from going anywhere. Because, young man, that is not the case.
Yes, sir.
You are smart enough. You can do whatever you want to do. You can stay away from whoever you want to stay away from. The problem is, quite frankly, you're just being stupid. You're just playing games. And this is what happens. You end up in jail on $100,000 cash bond, and you're about to go now.
I understand. I'll take full responsibility. I appreciate it.
Anything else you want to tell the court?
No, sir.
And Judge, I don't know if it would have any impact on the court one way or the other, but I don't know if the court wants to wait to see the disposition of those cases, or if you're just going to follow the recommendation.
I'm not gonna wait. If there becomes a certain disposition regarding those cases, certainly I'll take that into consideration in modifying his sentence on the case, but I'm not gonna do that at this point in time. I keep giving him breaks, keep doing everything, and he keeps just coming back to this court, disappointing this court and ending up with more charges, just time and time and time again. And so in that respect, I'm done. I'm gonna revoke the defendant's probation. He is to complete the in-jail on farm program while he's incarcerated. I'm going to waive all remaining terms except the financial obligations on this case, discharge the defendant from probation without improvement. I will sentence the defendant to 365 days in jail, credit 162 days served. Defendant is to serve the balance.
Your Honor, the court ordered the Don Farm program. Probation also requested the DV program. So if you just requested DV, the court want the defendant to perform both or just one or the other?
I should have said in-jail DV program is what I meant to say. Thank you.
Okay.
And just like that, we watched a grown man talk himself straight into a jail cell, no twist, no shock, just pure self-destruction in real time. The system might not be flawless, but it recognizes patterns, and this guy's made his impossible to miss. Repeated violations aren't mistakes. They're choices, and dangerous ones. Judges like Simpson aren't being harsh. They're being done. Done with people who treat the courtroom like a revolving door. And here's what most people miss. Violating a restraining order doesn't need violence. Just showing up can land you felony-level trouble. So what do you guys think? Is this reckless stupidity or calculated defiance? Drop your thoughts below, hit that like button, and subscribe for more courtroom chaos. Thanks for watching. I'll catch you in the next one.